What if I told you that the difference between a functional, stable democracy and a state ruled by absolute arbitrary power is just one document?
It sounds dramatic, but it's fundamentally true.
We often talk about individual laws, we talk about fundamental rights, but what is that foundational bedrock? The thing upon which every single law, right, and government structure actually rests.
That foundational bedrock is the Constitution. And today, we are undertaking a really critical deep dive into the very essential concept that defines modern governance.
Okay.
For any serious learner, and I mean especially those preparing for analytical exams, understanding the basic structure of the polity.
Well, it isn't merely academic theory.
No, it can't be.
It's the essential operating manual for every single political mechanism we'll encounter later, from the Supreme Court's power all the way down to the structure of the local panchayat.
Okay, so let's unpack this for the focused learner. Our mission today is to define the concept of a constitution using the foundational wisdom of M. Laxmikanth's Chapter 3, and then immediately connect that theory to the analytical demands of the UPSC mains examination.
Exactly. Welcome to the deep dive, curated specifically for UPSC preparation by the team at Simplified UPSC by PPP. We take your extensive sources, cut through the noise, and deliver the highest yield information right to you. And before we begin this critical discussion, and I say critical because this material is just so foundational, if you find this deep dive useful, please humbly consider subscribing to the Simplified UPSC by PPP YouTube channel.
Really does help.
It does. And maybe joining our paid membership tiers if you are capable of supporting us. It is the backbone that allows us to keep bringing you this super useful, expert-curated content free of charge to thousands of other learners.
On that note, a huge shout out to all our existing members. Your dedicated support, it enables the continuous creation of this resource, allowing thousands of learners to access high-quality, structured preparation materials. So thank you.
Absolutely, thank you. And don't forget to like this video, share your valuable comments below. Your feedback really does shape our approach and helps us refine these dives. Quick resource note, free notes, including practice PYQs directly related to today's concepts, are available on our Telegram channel.
And for our Legend YouTube members, the premium notes with extra PYQs and detailed model mains answers for those complex questions are waiting on our Discord channel. So do join us there.
Yeah, please do.
This discussion, I think, provides the essential vocabulary and the conceptual framework you need to tackle advanced topics. Things like the implementation of fundamental rights, the constraints on executive power, and the complex structure of our federal system.
Right.
Grasping this chapter means moving past mere memorization and into true analysis.
Let's start with the very basics then. The nomenclature. Where does the power of this single document originate conceptually?
We have to start with the origin of the term itself. It's pretty straightforward. The word constitution is derived from the Latin word constituere.
Okay, constituere.
Yeah, which literally translates to establish or to set up. In the classical sense, this meant establishing the form of the government itself.
So it's fundamentally about establishment, about, setting something into stone. But in the modern political sense, what specific system or relationship does it establish? It has to be more than just drawing up boundaries, isn't it?
Oh, absolutely. In the modern context, especially for democratic or republican governments, the Constitution establishes two key fundamental relationships. They're distinct, but they are entirely interdependent.
Okay.
If you miss one, you really miss the purpose of the whole document.
So what's the first one?
First, it dictates the organization and the working of the government itself.
The nuts and bolts.
The nuts and bolts.
Yeah.
It determines how legislative power is generated. So parliament, how executive power is exercised, which is your cabinet bureaucracy, and how judicial power is implemented through the courts. It details the entire distribution of power.
The structure, composition, powers, procedures, all of it.
All of it.
Yeah.
It's the structural map, the plumbing of the state, as you said.
Right. And the second relationship.
And this is perhaps the more crucial one. It establishes the relationship between the government and the people.
Ah, okay.
It explicitly details citizens' rights, their fundamental freedoms, their duties, and critically, the limitations that the state must observe in its interaction with the individual. This is where liberty enters the framework.
This inherent duality, the establishment of power centers and the definition of the boundary lines they cannot cross, that's what gives the Constitution its immense authority.
Yes.
It simultaneously enables the government to function while restraining it from becoming arbitrary.
And that leads us directly to the powerful nomenclature used by political scientists,
Right.
which the source details meticulously. Every single descriptor highlights a unique facet of the Constitution's supremacy.
Let's delve into those,
Yeah.
because understanding the terminology, I think, provides immediate insight into the legal philosophy that guides our entire system.
Well, the first, and probably the most easily understood, is that it is the fundamental law of the land.
Right.
Now, that's a simple statement, but it has profound legal consequences. It implies that every other law, every ordinance, every administrative action, they must all draw their validity from this one source.
So if we imagine the legal system as a pyramid, the Constitution isn't at the top of the pyramid. It's like outside and above it, right?
That's a great way to put it. It's the base upon which the pyramid is built. So a simple law passed by Parliament, even if it's passed by a unanimous majority, can be struck down if it is inconsistent with this fundamental law.
And that's the essence of it.
That is the essence. And this supremacy leads to its second and third titles, the supreme law of the state and the basic law of the country. These terms just cement the idea that no ordinary legislation can stand if it contradicts a basic constitutional mandate.
Which guarantees a certain level of stability and, I guess, predictability in governance. We also call it the instrument of the government, which I suppose describes its functional role. It's the operational rule book.
It details everything from the composition of the Council of Ministers, Article 74, all the way down to the formation of the smallest administrative unit, the panchayats. It's the rule book for institutional logistics.
But the deepest, most philosophical terms, you said those are the most important for the analytical learner.
Yes, absolutely.
Yeah.
The Constitution is the basic structure of the polity and, most powerfully, the Grun norm of the country.
Grun norm. Okay, that is a German term. It sounds highly technical and very philosophical. Can you elaborate on what Grun norm specifically conveys that a term like supreme law does not?
Sure. Grund norm is a concept that comes from Hans Kelsen's pure theory of law. Kelsen argued that in any legal system, there has to be a basic foundational norm, a hypothesis, really, from which all other norms or laws derive their authority.
So it's not a law itself?
In a conventional sense, no. It's the source of validity for the entire legal order.
Okay, so if the Constitution is the Grund norm, it means we accept its authority not because some other law made it supreme, but because the entire legal system presupposes its supremacy just to function.
Precisely. It's the ultimate source of legitimacy.
I see.
When the Supreme Court of India strikes down a parliamentary act, it's not merely exercising a power, it is enforcing the Grund norm. It's stating that the parliamentary act has failed the test of ultimate legitimacy established by the Constitution.
That is a crucial distinction. The Constitution isn't just the most important law, it is the source of legal authority itself. So if the government violates the Grund norm, the entire constitutional order is threatened.
Yes, and that explains why the judiciary in India, particularly since the 1970s, has taken such an expansive view of its role as the guardian of this foundational document.
Which is all solidified by the doctrine of the basic structure, right?
Right. While the source doesn't detail the case itself, the principle that the Constitution has a basic structure, certain features that cannot be amended even by Parliament, ensures that the Grund norm is not only supreme but also immutable in its core identity.
Which guarantees its stability, preventing any temporary political majority from just fundamentally altering the nature of the republic.
Correct. So Part I establishes that the Constitution is the apex of the legal system, defining both the functional power of the state and the fundamental rights of the citizen, and all of it rests on this deep philosophical basis of ultimate legitimacy, the Grund norm.
And that framework is what enables the next step, the deliberate design of the document itself. We move now to classification, looking at how different constitutions come into being. The source clearly distinguishes between those that are deliberately created and those that evolve organically. Why is the process of creation so important to the document's character?
Well, the method of creation determines so much. It determines the document's rigidity, its clarity, and its initial source of authority. An enacted constitution is one that is consciously and deliberately formulated and adopted by a designated singular body.
And we also refer to this as a written or conventional constitution. The Indian and American constitutions are the primary examples here.
That's right. For an enacted constitution, the key steps are very clear. First, a dedicated body, a constituent assembly, a constitutional council is formed.
With a specific mandate and time frame.
Exactly. Second, the provisions are consolidated, usually into a single, unified, codified book. And third, The document has a definite commencement date, which provides immediate and unified legal authority across the whole territory.
Let's focus on the Indian experience. We know the Constituent Assembly was formed in 1946. It took what? 2 years, 11 months, and 18 days of intense deliberation. The eventual adoption on November 26, 1949, and commencement on January 26, 1950. Those were definitive acts of sovereignty.
They were.
So what did this deliberate, enacted choice gain for India?
It gained immediate, undeniable moral and legal authority. In a nation emerging from centuries of colonial rule, one characterized by immense diversity, regional, linguistic, religious, enacted, written constitution provided essential unity and clarity.
It just stated, unambiguously, what the rules of the new political game were.
Exactly. It prevented regional authorities or powerful groups from questioning the foundational legality of the new Union of States.
And given that the Constituent Assembly borrowed so heavily from other constitutions and certainly drew roots from the British legal framework, the act of deliberately debating and adopting these provisions gave the final text a distinctly Indian legitimacy.
That process of conscious choice was absolutely vital. It ensured that even borrowed features were ratified by the representatives of the Indian people. It turned administrative convenience into a sovereign mandate.
But if we look at the other major democratic model, the British one, it followed the complete opposite path. What distinguishes an evolved constitution, the so-called unwritten one?
Well, the term unwritten is a bit misleading.
Right, because parts of it are written.
Significant parts are certainly written. Magna Carta, statutes of parliament, key judicial decisions. However, an evolved constitution is characterized by the absence of a single codified document drafted at one point in time by a dedicated assembly.
It's more organic.
It is. It's the result of gradual historical development, accumulated tradition, established customs, and unwritten political conventions built up over centuries. For instance, in the British system, the convention that the sovereign acts on the advice of the cabinet is arguably more powerful than many written laws.
So I have to ask a challenging question here. If the British Constitution evolved successfully over centuries to become one of the most stable democracies, why did India, which borrowed its entire parliamentary system from the UK, choose the riskier, more rigid path of an enacted constitution? Why not just let the system evolve organically?
That is a fundamental analytical question, and there were several key reasons for that choice. First, speed and unity. India needed a functioning state apparatus immediately upon independence. It had to handle partition, the integration of princely states, vast socioeconomic challenges.
There was no time.
There was no time. Evolution takes centuries. India didn't have that luxury.
Okay, that makes sense. What else?
Second, diversity and assurance. An evolved constitution relies heavily on consensus and tradition. India was, and is, characterized by deep divisions. A written document provided explicit, legally enforceable assurances, like fundamental rights, special provisions for scheduled tribes and castes, that an unwritten tradition just could not guarantee, especially to minorities.
Right, had to be spelled out.
It had to be. And third, clarity of federalism. India chose a highly centralized federal structure. An explicit division of powers, like the lists in the 7th schedule, required an enacted, detailed text. Evolved constitutions are typically unitary, which would have risked chaos in a nation of India's size and complexity.
So, the choice of an enacted constitution was a pragmatic, strategic decision. It was rooted in the unique demands of a newly independent, highly diverse, and structurally complex nation. It ensured stability and provided clear lines of authority from day one.
And this codified clarity then feeds directly into the philosophical core of our discussion, the idea of restraint.
We now pivot from the structural definition of the document to the philosophical intention behind it. We've established that the Constitution is the supreme rulebook. But why is it not merely a rulebook for administration, but primarily and essentially a tool for restraint?
That is the crucial insight. It's what separates simple government from legitimate constitutional governance. The core philosophy is constitutionalism, and it means essentially limited government.
Limited government. That distinction is paramount.
It is. You could have a document titled The Constitution of Country X, but if that document vests unlimited power in the hands of the executive or single ruler, it lacks constitutionalism entirely.
Right. It's just a piece of paper then.
Exactly. The history of the 20th century is littered with autocratic states that adopted highly detailed constitutions, merely to lend a veneer of legality to arbitrary rule. If the government's power isn't truly limited by effective checks and balances, it is a document of power, not constitutionalism.
So constitutionalism is the principle that the power of the government must be effectively constrained by the supreme law.
Yes. It ensures that those who govern must do so not through their own unrestrained will, but according to prescribed laws and procedures, ensuring transparency and accountability.
Let's bring in the political thinkers who frame this idea of restraint. Their definitions really drive home the antithesis between constitutionalism and despotism.
Indeed. Thinkers define this concept by contrasting it with arbitrary power. Rouseck, for instance, defined constitutionalism as the antithesis of government by the unrestrained will of rulers.
The antithesis, so the direct opposite.
The direct opposite. It assumes limitations on government, contrasting it explicitly with arbitrary government. The moment a ruler acts on whim, based on personal preference rather than established law, the system has failed the test of constitutionalism.
That makes it a safeguard for the citizen. If the rules are clear, public, and applied equally, the citizen knows the boundaries of state power and therefore the extent of their own liberty.
And this leads to Friedrich's definition, which is more focused on the mechanism of enforcement. He described constitutionalism as providing a system of effective restraints upon governmental action.
Effective restraints.
Effective, composed of rules ensuring fair play, thereby rendering the government responsible. Responsibility, accountability, and restraint are all inseparable.
And this philosophical framework, this is the engine room of our fundamental rights. For the learner, grasping this connects the theory of constitutionalism directly to the operational articles of the Constitution. I mean, why does Article 32 make the Supreme Court the defender and guarantor of fundamental rights? It's because these rights are the actual legally enforceable mechanisms of state restraint. They are the limits imposed by constitutionalism.
Exactly. You've nailed it. Constitutionalism is the soul, fundamental rights are the body, and judicial review is the protective shield.
That's a great way to put it.
If the state attempts to pass a law that violates the right to equality or the right to life, the judiciary steps in, using the authority granted by the enacted Constitution to enforce the philosophical limit imposed by constitutionalism.
Let's delve deeper into that enforcement. The efficacy of constitutionalism in India was, it was dramatically tested and evolved through judicial action. The Constitution, as originally drafted, used the phrase procedure established by law for Article 21.
It did, which sounds very procedural rather than the American due process of law, which suggests judicial scrutiny of the fairness of the law itself.
So that was a constrained interpretation initially.
Very constrained. But the landmark 1978 Maneka Gandhi versus Union of India case fundamentally changed this. Before Maneka Gandhi, the interpretation meant the legislature could take away life or liberty so long as it followed the process prescribed in its own legislation, no matter how harsh or unreasonable that procedure was.
But the Maneka Gandhi judgment transformed Article 21. How did it inject true constitutionalism into the system?
The Supreme Court, in that case, ruled that the procedure established by law must satisfy the tests of Articles 14 and 19. It held that any law curtailing personal liberty must be fair, just, and reasonable.
So in essence, the court read the substantive content of due process into Article 21.
It did, thereby ensuring that legislative action itself must be non-arbitrary.
This is the practical manifestation of constitutionalism. The court effectively said, we will not just check if you followed the steps. We will check if the steps themselves are just.
A fundamental shift.
It fundamentally enhanced the judiciary's power and transformed the fundamental rights from mere restrictions into substantive guarantees of liberty against the state's arbitrary will.
And this is why the concept of constitutionalism is so much more potent than the mere definition of a constitution. It demands that the entire legal, political, and administrative system adheres to the rule of law,
where everyone, from the lowest bureaucrat to the prime minister, is bound by that supreme law.
And that supreme law itself guarantees non-arbitrariness.
Okay. We have established the theoretical foundation, the Constitution as the Grund norm, and constitutionalism as the required restraint on power. Now, let's prove the high yield of this knowledge by linking these abstract concepts directly to the complexity required by past mains examination questions.
This is where we move from theory to application. The foundational concepts from Chapter 3 are, they're the keys that unlock analytical writing across governance, social justice, and even internal security.
Okay, let's analyze a question about the state's duty to its citizens. The UPSC mains question on the Food Security Bill, Q-4. Critically discuss various apprehensions in its effective implementation.
So, first question, why does the state enact a law like the Food Security Act in the first place?
Because the Constitution fundamentally mandates the establishment of a welfare state.
Exactly. And that constitutional mandate is housed primarily in the Directive Principles of State Policy, the DPSP.
The source notes that the DPSP are fundamental to the governance of the country. So which specific articles underpin this obligation to ensure food security?
Well, you look to Articles 39B and 39C. Article 39B directs the state to ensure that the material resources of the community are distributed for the common good.
Right.
And 39C directs the state to ensure the economic system doesn't result in the concentration of wealth.
But these are non-justiciables, right? You can't take the government to court for not following them.
Correct, under Article 37. But, and this is key, judicial interpretation has fused them with the justiciable fundamental rights. The Supreme Court has repeatedly held that the right to life under Article 21 includes the right to live with dignity.
Which encompasses the right to food and other basic necessities.
Precisely. So food security is not a matter of government charity or discretionary policy. It is a direct constitutional imperative rooted in the preamble's guarantee of social and economic justice.
So implementation challenges, corruption, poor targeting, whatever, are therefore a failure to operationalize the fundamental philosophy of the polity.
A failure to make the abstract concept of a welfare state a reality. And the ability to discuss this failure within that constitutional framework is what separates a mere descriptive answer from a truly analytical mains answer.
Okay, let's connect the same structural philosophy to historical challenges. Question Q.8, which links land reforms, agricultural productivity, and poverty elimination.
Land reforms. This was perhaps the most immediate post-independence clash between the structural ideals of the Constitution. They required radical state intervention to restructure agrarian society.
Which immediately came into conflict with the fundamental right to property, which was then Article 31.
Right, and this required the enacted law, the written Constitution, to be flexible enough to accommodate vast social engineering.
So its stability had to allow for crucial adjustments.
Yes, primarily through the first constitutional amendment in 1951, which introduced Articles 31A and 31B and the Ninth Schedule. These provisions created exceptions, allowing the state to proceed with agrarian reforms without fear of challenge on the grounds of violating Articles 14 or 19.
This illustrates a key point about our Constitution. It is enacted and supreme, but it's also flexible.
It is. The amendment power was used to prioritize the directive principles, like equitable distribution of wealth, over individual property rights when it was necessary for the broader welfare mandate. The Constitution was deliberately designed to facilitate, not obstruct, this kind of transformation.
Let's move to the administrative structure. We have a question linking Article 244 relating to the administration of scheduled and tribal areas to national stability. It asks us to analyze the impact of non-implementation of the provisions of the Fifth Schedule on the growth of left-wing extremism.
This is a powerful demonstration of how the abstract concept of constitutional structure dictates national security outcomes. The Constitution is not a monolithic administrative code. It explicitly details special, tailored provisions for marginalized groups and vulnerable regions.
It recognizes the unique needs of tribal communities.
It does. Article 244, combined with the Fifth Schedule, mandates a highly specific, protected, and semi-autonomous governance model for these regions. This structure is intended to prevent land alienation, protect traditional customs, and ensure tribal participation in local governance.
Through institutions like the Tribal Advisory Councils. So the Constitution established a dedicated mechanism to maintain integration, ensure social justice, and preserve cultural identity in these areas.
Correct. So the failure of constitutionalism here manifests as the failure of implementation. When the state's administration fails to respect the mandates of the Fifth Schedule, when land is alienated, when resources are exploited by outsiders, or when local governance is neglected, it violates that special constitutional trust.
And what is the consequence of violating this particular constitutional obligation?
The consequence is a constitutional vacuum, a vacuum that gets filled by political alienation and economic deprivation. Left-wing extremism thrives in areas where state governance fails to align with constitutional guarantees of justice and protection.
So the failure to observe Article 244 is essentially a breakdown in the basic structure of the polity in that region,
leading to anti-state movements and serious internal security threats. This clearly shows that a comprehensive understanding of the Constitution is essential for internal security analysis. The document doesn't just regulate Parliament, it defines the conditions for peace and stability at the grassroots level.
Finally, let's look at how the constitutional framework governs India's interaction with the global economy and its ancient cultural identity. Consider Q.7 on the impact of liberalization on Indian companies competing with MNCs.
Well, liberalization was a massive structural shift in the state's economic philosophy. But the Constitution, as the supreme law, implicitly defines the sovereign capacity of the state to regulate its economy, even in a globalized world.
And that regulation has to constantly balance two forces.
Two forces, exactly.
Yeah.
The fundamental rights guaranteeing economic liberty, like Article 19 and the directive principles aimed at equitable wealth distribution and protecting the vulnerable.
So when multinational corporations enter the Indian market, the strength of the Constitution dictates how effectively the state can regulate capital flows, environmental standards, and labor practices.
Absolutely. The concept of the Constitution, in this context, defines the limits and scope of state intervention. The state must regulate MNCs to ensure competition is fair and that growth is balanced with a constitutional commitment to the welfare of its citizens.
And let's conclude with the cultural thread. The source mentions the uniqueness of ancient Indian civilizations surviving without a breakdown. How does the modern Constitution consciously ensure this survival?
The Constitution serves as the ultimate modern legal mechanism for preserving India's composite tradition. It's not an accident of history that this diverse culture continues. It is a constitutional commitment.
Where is that commitment anchored?
In several places. The preamble's goals of fraternity and dignity of the individual. More explicitly, Article 29 guarantees the protection of the language, script, and culture of minorities. This places a positive obligation on the state to allow cultural difference to flourish.
And later, the fundamental duties were added.
Yes. Article 51A explicitly obligates every citizen to promote harmony and the spirit of common brotherhood, and to value and preserve the rich heritage of our composite culture.
This just demonstrates the comprehensive reach of the foundational document. It doesn't just manage budgets and elections, it consciously attempts to structure and safeguard the entire socio-political and cultural fabric of the nation.
We've concluded this deep dive by establishing that the Constitution is far more than a rule book. It is the Grun norm, the supreme law that consciously establishes government structure and, through the philosophy of constitutionalism, severely limits its power.
And it was an enacted document, deliberately chosen.
Deliberately chosen by the Constituent Assembly to provide a clear, accountable, and stable framework for the Union.
So what does this foundational concept truly mean for you, the learner? Understanding the concept of the Constitution is your absolutely necessary foundation. It's the difference between memorizing Article 32 and grasping the constitutional intent behind it.
That fundamental rights are the ultimate expression of constitutionalism.
The non-negotiable restraint on state power. This analytical depth is essential for tackling the complex questions required by the mains examination, as we've seen with the detailed linkages across policy, security, and governance. So we've established that the Constitution is specifically designed to impose restraints on government. This raises a profound question, especially for the Indian model. In a parliamentary system, the legislature and executive are closely merged. Power often coalesces around a strong ruling majority, a prime ministerial government. If the parliament, backed by a strong majority, constantly uses its constitutional power of amendment or ordinary legislation to modify the laws, does the philosophical restraint embodied by constitutionalism ever become fragile against political expediency? The written word can be changed.
That's a fascinating thought.
The effectiveness of the constraint relies not just on the text, but on the political maturity and restraint of the majority itself. Something for you to mull over as you study the subsequent chapters on the structure and functions of the executive and legislature.
It is. It reminds us that the preservation of constitutionalism often relies as much on non-codified democratic conventions and institutional integrity as it does on the written text itself.
This was another successful deep dive, thanks to the critical sources you provided. We hope this has been a high-yield use of your study time.
Remember to check out the free notes and practice PYQs available on our Telegram channel immediately.
And for our Legend members, make sure you download the premium notes with extra PYQs and model mains answers on our Discord channel. And don't forget to like this video, share your valuable comment, and subscribe. Your support, especially through paid membership tiers, helps the Simplified UPSC by PPP team continue creating this essential, expert-curated content.
Keep diving deep, and we'll see you in the next analysis.